And
All right, I'm going to get us going because we have a whole lot of ground to cover on this one. So everybody hit the restroom, get a drink, whatever you need to do, and sit back down. Hi, my name is Susan Hayes, and I'm going to, because
hey, everybody,
thanks,
we're ready to start.
And a couple of quick housekeeping things for y'all. At the end of this slideshow, there will be a QR code that links to an 11-page chart, most of which we're going to zip through, that outlines the current state of hemp regulation in Texas and kind of compares it to where we are with teacup. It is not legal advice. It is a chart that has been evolving since the last policy conference we had. Andrea and Katie from the Baker Institute, who may be in the audience, and I whipped it up for that one, and we keep updating it as things go on. And then Chelsie pitched in this last round. And you will see that the theme on this presentation is moving targets, because that's what we're all living with right now. First off, we've got a whole alphabet soup of state agencies that are involved in Texas, which has happened because we never really sat down as a state and said, how are we going to do this big thing and do it in any streamlined fashion? And we can talk about some of those, we'll talk about some of those agencies more, but you've got TDA on the farmer side, dishes on the consumable side, now TABC on the consumable side, DPS on teacup and busting people with marijuana, and then also local law enforcement as well. All right, quick overview of what just happened for anybody who wasn't paying attention or is still confused. We had a ban bill passed, get vetoed. The governor, Abbott, then issued an executive order directing TABC, the Alcoholic Beverage Commission, and our state health department to make rules, particularly emergency rules to age gate products. And Dishes is still considering and just probably barely wading through all the comments they got that were due Monday for the rulemaking. There have been some rumors flying around that Dishes is about to issue some random emergency rules. That's not true. I'm 99.99% confident, because we have a process for rulemaking in the state, and it's going to take them a little while to get to final. All right, we're going to talk a little bit about litigations. We can all think about regulations and statutes, but when lawsuits get filed, sometimes that can throw a punch to the system. So Andrea, give us a few comments about the Sky marketing case and where that is.
All right, everybody, my name is Andrea Steele. I'm an attorney with the Banks Law Firm. I'm based out of Houston, and I represent cannabis businesses across the country, transactional work, business contracts, regulatory admin. So I did have the honor and pleasure of architecting and drafting the Delta 8 lawsuit that garnered the injunction that is why all of these shops are open. So everything so the litigation piece of things, I can't see the chart, but the litigation piece will come up as we're talking about regulations. And also Chelsie and Susan can speak on this, because when the rules got passed in 2020, the original rules got passed, there was also litigation. And if these rules pass, if the current proposed rules pass as written, there will be more litigation. So it's going to come up in the regulatory process, because when the state overreaches or when things don't make any sense, and you just heard, and all of you in the industry know, nothing makes sense in cannabis, whether you're talking about hemp or marijuana, litigation comes up all the time. So it's going to happen if the rules pass as drafted. You want to talk about the smokable case, why we have smokables that you can sell and distribute? I mean, well, yeah.
Sure. So in 2020, when Dishes adopted the current iteration of our consumable hemp rules, One of my clients, Crown Distributing, which is basically a holding company for a lot of subsidiary hemp companies, we decided to sue the state of Texas, the executive commissioner of dishes, for the adoption of two things. Number one, the prohibition on retail sale of smokable hemp and the prohibition on distribution of smokable hemp. And then number two, the prohibition on manufacturing and processing. The retail side, we challenged as there's something called an ultra vires action of an agency, meaning the agency wasn't authorized by the legislature to do what it did. It's acting sua sponte on its own outside of a direct statutory directive. We're really confident we would win on that one. And on the second one, we were confident under the existing precedent, which was an economic liberty case called Patel. We went up and down between the intermediate appellate courts and finally the Texas Supreme Court, where we ultimately lost on the processing and manufacturing point. The Supreme Court created a new exception to Patel, which was a prevailing precedent. And the question I'm getting right now from so many people calling our office is, how is dishes going to ban smokable hemp again when you already won on this issue? We did. This is a technical issue, but the Texas Attorney General's office, the decisions at the lower court and the intermediate appellate were not very favorable on the retail rule. So in light of that, I think the Attorney General's made a strategic decision to drop the retail challenge. So we went up to the Supreme Court solely on the manufacturing and process side. So a judicial doctrine called res judicata, which kind of means we've already talked about this, we've made a decision and let it lie. It's not applicable here because we didn't try that particular rule, which is why Dishes is now trying it again.
But and how are they trying it? Right, they're trying it by turning Texas into what we call a total THC state. For those of you that may or may not know, I'm sure if you're in the industry, you know, but total THC is the combination of THCA plus or a portion of THCA plus the Delta-9, and it calculates the total potential Delta-9 that could be in a product. And so the way that the proposed rules are drafted right now, or the way the current rules are drafted, which you just heard about, is they test for Delta-9 THC. That is the cannabinoid that is in the law that is tested for, that has a 0.3% threshold. THCA, so the way these proposed rules are drafted is that you cannot have a product unless the certificate of analysis shows that its total THC or total Delta-9 THC is below 0.3%. That's not what our law says. So our law is on Delta-9.
Not what the statute said.
Or what the statute says. Right.
But the problem here is THCA is tetrahydroquinolic acid. It's the precursor to Delta-9. And when you heat it, it decarbs into Delta-9. So in doing so, in drafting these rules to account for total THC, and we'll give this state a little bit of credit. We didn't go after the minor deltas like some of the states are doing. But in doing so, all of these, for example, and I'm not gonna comment on an opinion on this, but the diamond crusted 97% THC moon crystal pre-roll that you can buy at the gas station down the road would thus become illegal.
Right. I'm going to do a slight devil's advocate here. The statute doesn't say that, true, but the only statute we have on hemp right now was the 2019 original law, which at the time, Farm Bill had just passed. Everybody was very focused on plants in the field and not product in the stores. The Farm Bill punched to the USDA to make rules. Texas needed a hemp plan that mirrors the federal plan. The USDA was very clear in its rules that for hemp in the field, you have to use a total THC measure to calculate for the decarboxylation of THCA into Delta-9 when it's heated or smoked. And Texas copied that literally verbatim with the Ag Department rules. But it wasn't written that this too shall apply to consumable hemp products or CHPs. So that was the giant loophole. And lo, these many years later, the legislature has never managed to pass an update bill, or what I would originally have called a cleanup bill. Once you pass a bill on a new thing, typically the next session, the legislature will do a cleanup bill to kind of, we forgot about that, we forgot about this, let's fix it. So it is in that omission that all of these products have been able to be sold in Texas.
Well, and technically we messed up at the federal level as well. I helped on some of the language in the 2018 Farm Bill, and what people really negate when they're looking at the definition of cannabis sativa L and how these were intended to be properly calculated by basically it's a group of about 29 core senators who really pushed the 2018 Farm Bill. is there's two predicate words to the definition of hemp that everybody ignores. The plant, cannabis sativa. So the way it was supposed to work in theory for products was, for example, if you had a gummy, you divorce out the pectin, the sugar, those other fillers that go into that, and you take the totality of the plant material, and in that it's supposed to be the 0.3%. That is not how it played out in practice, obviously.
Well, because that's not what the rest of the law says, because all the other words in the rest of the definition go into cannabinoids, acids, isomers that are also part of the plant. And then THCs in hemp were descheduled. So it's going to be an interesting party, but I want to say that you said it's a cleanup. I don't think a switch.
We're beyond a cleanup at this point.
Well, yeah, but I don't think changing from Delta 9 to total THC is a cleanup. Like, that is a fundamentally different calculation, right? If you have 1 + 2, you get 3. They're telling us 1 + 2, you get 1, right? What I have the potential to be, they're holding you accountable for what you have the potential to be, not what you are. So I think that's a big change.
I think DISH is going to have a difficult time with it, considering the exact predicate statutory language says with a Delta 9 concentration of no more than 0.3%.
Yeah. And the original law talks about oil and CBD mostly. And the market is well beyond that. All right, moving on to the chart. And what we have on the left is the laws concerning teacup or marijuana, on the right, hemp. And then I'll let y'all point out our big differences between the two in Texas law, particularly in how the teacup language has shifted this last session.
I'll speak to teacup because I crafted a lot of the language in HB 46. The big changes, we used to be capped here. We started at it, a very menial cap. We were 1% by weight of total, well, technically wasn't total THC, it was THC. And what we pushed for and were able to obtain in this last session was, I use the term dosage unit. So now that the statute is couched in terms of a milligram cap and a dosage unit, and you get 10 mg THC per dosage unit. There's some language on the amount of a prescription medication that you can have within a 90-day window, but it allowed us to have some slight expansion within the program for some patients who really needed this.
I have a question about that. So it's 10 milligrams of THC in each dosage unit. The way that I read that is you could be prescribed more than one dosage unit.
Absolutely. Yes, absolutely. So that's the whole point. So for example, our veterans who have PTSD, when you're having a severe episodic event, you can't wait on a gummy to take impact for an hour. And for so many years within the program, I've watched pediatric patients, for example, who are having to titrate their dosage, which leads to cumulative oil in their body. So they can't go to school because they're in the bathroom with excessive diarrhea all day. So allowing that dosage unit, especially with pulmonary, takes care of those people who have, like, for example, instantaneous episodic events. They will now have metered dosage with pulmonary available, if we can ever get the agencies to get this rolled out, which I'm quite sure I'll talk about up here. But it allows them to have that metered dosage that will cut off, for example, the 2 pulmonary inhalation devices we just had approved are 2-second battery timers. So it will give you within that dosage limitation. But yeah, so theoretically, if you need 100 milligrams per day, you would have 10 dosage units within the unit or device.
That's I read it that way too. That, like, there's not a cap.
It's a cap that's not a cap.
But then
It's cap.
on the hemp side, this past legislative session, vapes were banned. So Teacup was able to get pulmonary in their program, but any hemp cannabinoid vapes have been banned in the state of Texas, effective September 1st.
In theory.
In theory.
I see them all over the place.
And the funny thing is that Texas comptroller, I messaged them because what was that? SB 2020? It's 2020. Okay, so they basically they meant to ban devices, and I brought this up to Senator Perry's office when it happened. They defined pulmonary device, they defined like electronic device, and then they went on to define electronic liquid. But I'm not sure what happened with Ledge Council, but even though electronic nicotine delivery system, which is an ENDS device of vaping, was defined in the predicate, it's nowhere in the bill. So they meant to put the device in there too, but it ended up arguably only being the liquid. And the Texas comptroller, I emailed them back in August because I needed some guidance saying, what are you guys going to do here? And they said, we're really working on this issue. We'll get back to you. We'll email you when it's ready. I have routinely followed up with them saying, where's this guidance? And it hasn't come.
That may be why they're still all over the place. All right, next slide. And don't worry about writing these down. You can download them, but we just try to compile where you can find these laws. If you're interested in the business, it's probably a good idea, even if you're not a lawyer, to print this stuff out and just read through it.
Please do.
That's going to help you understand the world you're in.
We get asked questions that the answers are very clear. Some of them are not, but some of them are clear. Please read the rules and regulations. You guys are operating in the industry. Please read them.
And it will help you from inadvertently doing something bad because you don't always have a lawyer sitting on your shoulder telling you yes, no, as you go through your business planning or day-to-day life. All right, legality issues. Boy, is this a mucky one.
Okay.
I talk about the hemp side?
Yes. So hemp and THCs in hemp were descheduled under the 2018 Farm Bill at the federal level. It's also done at the state level. But in the legislation for HB 1325, the hemp legislation in Texas, we treat consumable hemp products as a food, which means all the food safety regulations are supposed to apply. Which means GMP, which means no adulteration, which means no misbranding. All of these things are applicable in the industry under the current rules. So people, want to say a lot of times we don't have regulation here. There is regulation here. What we're lacking is enforcement.
Absolutely.
Amen to that.
That's okay. We regulate like food. And okay, that's all I have on that topic. Yeah.
Federally, cannabis remains a Schedule I substance, meaning that it's placed in the schedule that next to heroin and LSD has no medically acceptable use and high potential for abuse. We do have a sort of bifurcated regime with it's called funny. Somebody asked me about it earlier, and they said I don't remember. I can't say the name of the amendment immediately. I was like Rohrabacher-Farr. Rohrabacher-Farr is a rider on federal appropriations bills that prohibits the Department of Justice and its subsidiary, the DEA, from spending any federal funding to go after a legitimate state medicinal program. Does not apply to recreational as well. So we have a very bifurcated regime in which states have valid medicinal programs and what the federal government views as invalid recreational programs.
We talked about this seconds ago, but one thing that makes me continually interested in this issue is it's so complex. It touches a lot of agencies, and that can make it interesting. It also makes it difficult to govern, and how much these agencies talk to each other can make a big difference in how well the laws can be implemented. And particularly on the federal side, it's so complex. You get agencies taking contradictory positions at times to really understand what's legal and what's not, or what's advisable and what's not.
In Texas this year, TABC got added to, you just mentioned they got added, but they got added only to the extent at this point that they can monitor their own licensees. So only the TABC monitors its own licensees. So only the alcohol shops are monitored by TABC. So we have an emergency rule from TABC that their licensees can't sell to anybody over 21. And then we have Dishes that also put an emergency rule in.
I'm looking at my watch because things are going to change soon. Dishes and TABC are in talks right now to come to an interagency agreement or contract of how Dishes can delegate some of their enforcement work to TABC. And that is happening because
what enforcement?
Unlike Dishes, which had, I think, 6 inspectors for the whole state of Texas?
It was 3 and then it was 5.
All right. TABC has boots on the ground. And that was a big reason why I think the legislature started looking to them to get them involved in hemp regulation. And they're also very experienced at inspecting stores, building cases against bad actors. And
we also have the largest THC beverage market in the U.S.
All right, now we're getting into some meaty topics with applications, license, everyone's favorite topic their second favorite topic with the Dishes rules, the fees. And one of the reasons we originally made this side-by-side chart, because it was just so lopsided of how heavily regulated teacup is versus hemp when they're often selling what is the same products. So as we've all heard, Dishes is proposing fees upwards of $20,000 for retailers, 25 for manufacturers. I fully expect
Per location per year.
per location per year. And by the way, on the alcohol side, fees tend to be somewhere in the $1,500, $2,500 range for a 2-year period. We're going to see that change. Where the number lands, we'll see when Dishes publishes the next round of fees.
But we have, because of the way that our hemp program is set up, there is no, like, you can enter in any aspect of the supply chain. You're not like on the teacup side, you've got to be vertically integrated, but on the hemp side, you have various opportunities to be involved in the industry with license fees that are reasonable at this time.
Teacup fees are far from reasonable. Vertical integration means you have to have this whole supply chain from seed to sale. There's kind of this myth going around. People like to say our teacup program is fairly unregulated because our regulations are scant. We have a myriad of unwritten policies and procedures at the Department of Public Safety that I jump through daily for my dispensing organization licensees. And, one prime example here is if you look in our Texas teacup regulations, you will not find outside third-party testing whatsoever, but every single medical product brought to this market is reviewed personally by a pharmacist at TPS, and it is independently tested by an out-of-state laboratory. So the fees in teacup are exorbitantly high, some of the highest in the country. You're looking at about $500,000 for your initial license, and it's close to $320-ish every 2 years on your biannual renewals. Your registration fees for your employees really add up there. You have to personally register every employee that's going to be touching the controlled low THC cannabis material. And what's really more telling is, set aside these fees and everything. If you were to call my office and say, I would like to get a medical cannabis license, in theory, let's say the window is open, the first question I'm going to ask you is, do you have roughly $25 million in available capital that's not committed to build out your employees, everything else? Because you're a small fish in a big shark tank of well-funded MSOs who have multi-billion-dollar valuations.
Okay, let's talk about prevalence counts real quick. And when I was updating the counts of physicians and patients that DPS publishes with the teacup program, and there was a question, I think, one of the earlier panels to the legislators about why it's not more publication that teacup even exists. And there has been actually zero of state involvement with that. The number of physicians in teacup typically shoots up every time the legislature expands the program in terms of conditions. But for the last 3 months, it's been flat. There's been about 915 physicians in the program. And if the physicians are participating in the program, there's not access for patients. Why it flattened out, I don't know, but not surprised given how little attention.
It's not accurate. There's 917 registered, but the majority of dispensations come from a very, I would say, less than 20% of the registered physicians.
Yeah, that is also true. And then one thing you should all know about what DPS publishes for their patient count, that is ever not active. And it's only up to 135,000. I'm going to give you some perspective for that. In any state that has a full medical cannabis program, and by full, I mean doctors can practice medicine without legislators telling them how to dose or what conditions qualify, about 4% of the population signs up. And in the state of Texas, that'd be 1 million people. And what's your best guess on how many active patients right now?
I can tell you what it is based on market share of my dispensing organizations. Well, I have to think about some privilege issues here as I go through the whole life.
The ballpark?
I would give you a ballpark of 30,000 to 50,000.
Okay.
And the reason you see that 135 though is behind the scenes on the current registry, and a lot of people don't know this. The system is incredibly limited. So, for example, if let's say I need to go get a medical cannabis prescription, I start with one doctor, I don't like them, and I switch. You can't re-register me and Kurt with my accurate birth date. You have to make me a fake birth date so that I can then get again. So that if I don't like that doctor and I go to another one, I'm now in Kurt 3 times, counting as 3 separate patients for these numbers.
Yeah. Data is important with all this, and it's kind of messy. So,
and the department doesn't know.
Yeah. All right. Testing requirements. We got a couple. One thing we did in this chart originally is really highlight when DPS is making things up without going through rulemaking or publishing what their rules are. So anytime you see by DPS practice in the chart, that is something they're enforcing on the existing licensees. But if you're a company and you hired a lawyer to go tell you what the laws are, you could never find that, which is no way to run a railroad.
And on the hemp side, it's full panel, third party, lab certified testing. And it's also required that you test for heavy metals, microbials, impurities, residual solvents, pesticides. So all of these public safety items that are people want these products tested for, they are required to be tested for those products in Texas. Again, we have an issue with enforcement, but no, they are required.
Well, and with the one thing, you know, I think there's this myth out there that I hate the hemp industry because I am very passionate about medical, but I represent a ton of hemp clients and I have my own hemp beverage company. But one thing that really bothers me about the testing here is you won't find anything written about the third-party testing in DPS's procedures, but we have robust third-party testing that goes above what the hemp program requires. So, for example, every product we make is tested for aspergillus. I had to produce an aspergillus test for a vape product. Now, if you're in the audience, you know anything about cannabis, you know that it is impossible for a heated pulmonary product to test for aspergillus. On the hemp side, it's discretionary if you are going to apply aspergillus testing. This just has really never given a straight answer as to when that microbial testing. I remember when the rules were first adopted, they said kind of the products that require it do it, which in essence means food products and foods that are going in the human body. But there are a lot of companies out there that aren't testing for these products. So that unwritten rule that DPS, which has the stringent testing, probably should be codified and looked to by dishes.
But just, it makes me, I keep going back to this enforcement part because the public safety issues that get brought up oftentimes can already be enforced under the current laws and rules that we have. And I had a conversation earlier. Somebody mentioned, well, not somebody, the senator mentioned we should make sure we regulate the molecule. The molecule is not the problem. The behavior is the problem. There's a bad behavior that's going on, and that's what needs to be regulated. So the testing, like if dishes could get it together with giving us a real list of analytes and things that need to be tested for, they could actually go enforce it if they could, prove that, oh, if these products are so bad, they should be finding these residual solvents and then they can go get them.
And I just moved to the second slide on this topic with the proposed rules. And Ms. Steele, you want to tell us, we really had to summarize this on the chart because it's a lot in the proposed dishes rules. The record-keeping, quality control, and batch testing requirements that are likely to go into effect when dishes adopts by rules.
So I'm going to find whichever one I put this on.
All right, sorry, but
no, that's okay. And I'll probably just do a lot of it from memory because I don't get it. But they want master production record. Proposed rules want you to trace back all the way to the seed, wherever you're getting your product from, which I don't necessarily have a trace back problem with. I think that's a good supply chain practice.
Yeah.
But the way that our supply chains work, everybody knows oftentimes there's multiple manufacturers in the chain, right? You might have one grower, or you have at the end, but in the middle, there's multiple manufacturers. And the way that they have these rules proposed is that every single one of these manufacturers have to keep these master records. And a lot of times, because in the state of Texas, if you repackage a product, that's considered manufacturing. So if you white label a product, you put your name on it, your brand, you're considered a manufacturer. Manufacturers who aren't actually making their products they're not going to have these records. And so the requirement to have all these records just doesn't really make sense. I put that in my comments when I sent them. Hopefully they'll listen. But I mean, it does make sense to have good record keeping, but what they put in is far beyond.
I may argue with you about
that.
If I'm shipping a product, I need to know where the things in it came from, right?
The person you got it from needs to know where it came. The person who made it needs to know where it came.
I tell a client, if I'm out there putting
federal law puts it on the own label distributor. So under FDA,
takes responsibility, right? The name on the
label distributor.
When something goes bad.
So that's what you need to. So it does then you need to know. You're the manufacturer. You need to know that information according to that rules. Do you? Have you had it? Do you have it now? Because you are supposed to know that information. Currently, you're supposed to be able to trace it back. You're supposed to be able to show that your product was grown, the original source of it was grown under the compliant farm bill process.
In Teacup, we have robust tracing mechanisms. We can tell you down to the micro ingredient, where it came from, what it tested at. It's tested in accordance with pharmaceutical standards when it comes into the dispensing organizations. And it's funny to me for hemp. because if you're a dietary supplement manufacturer, U.S. law puts the onus on it's called own-label distributor. Even if you're white labeling and using 17 manufacturers in that supply chain, the FDA is going to come in and issue a Form 483 to you, the manufacturer, the one whose name is on that label, if you can't verify the quality, purity, traceability of those ingredients. So I for one, am a proponent of these batch tracing and record keeping comments, because I'm very proud to say here in Teacup, we've never had an adverse event, and the same kind of can't be said for the hemp industry, unfortunately. There have been adverse hemp events, but thankfully, well, I'm not saying not here in Texas, but across the U.S. there have been.
I'm going to start leaving this a little faster because we got a lot to go through to get to the end. All right, facility requirements. Reasonably similar. We do have, correctly, in the hemp regulations, some CGMP requirements kind of buried in there in the food safety rules that many may not know about. Yes?
Yes, because it incorporates the food statutes here in Texas, which apply CGMP regs. But for Teacup on the facility requirements, there are some things that are written in the regulations that actually are not enforced here. And then the, same old story, things that are not written in the regulations that are enforced.
Okay, then I'm going to talk about feet real quick in schools, because we're likely to see this come up next session. Right now, Teacup has to be 1,000 feet away from schools. Alcohol stores, 300 feet. The different versions of different bills during session had 300 or 1,000 for hemp. But if I were in the business, I'd be paying attention to how far away a hemp business I am from a school, daycare, etc.
Nursing home,
At least up may try to get a little further away, because we may see legislation putting that 1,000 feet number in it instead of the 300 feet number going forward. And satellite locations. This may be Chelsea's least or best favorite the topic.
Lisa, I'm salty about this.
And if y'all are familiar with the term, this is what Texas calls dispensaries, because we can't use real words at this stage. And DPS had refused to allow the 3 licensees to have more than one location, even though that is not the law. It doesn't say that in the statute. They never went through rulemaking to say that. That's just what they enforced. And that's a huge part of the reason why the Teacup program has been so inaccessible over the years. So to get a second location, they had to pass a law.
And we got an attorney general opinion directly telling DPS they were wrong. Statute speaks in terms of purposes of facility.
Proud about that part. And they still wouldn't do it.
And they still wouldn't do it. DPS has long maintained that in Texas, you cannot have overnight storage of medical cannabis anywhere. So this is very difficult, because if I have a, stage 4 pancreatic terminal patient in El Paso who needs their medication, we have to load up a Prius at 12:01 in the morning and drive it all the way over to El Paso and get it back to the facilities, which are centralized here around the Austin area. So to fix this, it is not my favorite to talk about, because somehow I got flubbed in the draft. And what I wrote was I tied it into, I spoke with Chief Mueller at DPS and said, what do we need to do to fix this? And my idea was to tie some type of allowable overnight storage per DPS RDS region, because DPS is in these dispensing organizations on a weekly basis. And all of the inspectors, pretty much all 3 of them, are located here in Austin. So my theory was, if I've got other regulatory division services offices across the state, it will fix this problem of where I'm not having to wait on someone in Austin to drive all the way down to Corpus Christi to check out, my client's new satellite location. So somehow that all got lost in translation and turned into these public health regions with dishes, which is insane to me, because the only portion of Teacup that dishes regulates, also something I'm not a fan of, is the approval of pulmonary devices, while the filler remains with DPS. It's honestly created a bit of an issue between the 2 agencies.
Let's talk about what these satellite locations can look like. At the last meeting of the advisory working group of DPS, this was discussed somewhat heatedly, because DPS didn't want any product to be visible to any customer until it's dispensed to them.
Is that a law? Just kidding.
Yeah, but take it over. And listen, I work with the DPS regulators every day. I have great respect for them. They are friends of mine, but there are a lot of unwritten practices that are directly contrary to the statute that we really try to work with the agency. So here's a prime example of what those satellite locations look like, and why I'm a little salty you raised this subject, because I just had a phone call about it about an hour ago. No, it's okay. I directly in the statute, I wrote that the existing dispensing organizations, what we call temporary dispensing sites, it's TDS locations where we could dispense product but not have it overnight. The statutory language is considered to be a satellite location. So on the passage of HB 46, every TDS should have automatically converted into a satellite location. That's not what's happening, and actually, I've heard Chief Mueller is taking a little bit different stance than what the statute says, and we're going to have some delay in satellite rollouts.
But generally, though, that the way they satellite, like, because I maybe not the specific one, but I like how they are rolling it out in that a teacup dispensing organization must open one satellite location in every region before it can open a second location in any one region, which is going to really help make sure that we have access across the state. So as more of the licensees come on and they start getting their satellite locations, that there will be eventually.
We've had a few approved, but I'm limited on what I can say at this point. There's a kerfuffle, but it's
And part of the discussion we had, I pointed out that when I go to the HEB pharmacy, I can see drugs, including over-the-counter dosages of the same drugs that are behind the counter, and that did not persuade them. We found and they may not do this or not, but they did in the meeting say, well, you can have empty packages out for customers to look at. All right, inspections.
It's so interesting to me that our law enforcement agency is telling us how to distribute Schedule I controlled substances.
It's so interesting to me that we put regulatory purview of a medical cannabis program under state troopers.
Right. All right, inspections. This is, like mentioned earlier, a big thing that's going to change because after the governor's executive order, TABC will be taking over a lot of this, including for the hemp-only stores. And for those of you who aren't familiar with alcoholic beverage laws, I was not before this last session. Alcohol licenses are privileged licenses. So if TABC tells you to do something, you do it, or your license is in danger. And that is baked into our alcohol regulations. All right.
They don't arbitrarily apply their regulations.
Available products. This is something that I think has really held the teacup program back because the hemp industry's been allowed to innovate, put different products on the shelves for better and for worse. Any comments about that, including the kind of dosages we see in the hemp market versus teacup?
Well, I don't have comments about dosages. It is bad actors can be found. You can find what bad actors are doing by going after their behavior. I'm just going to say that. But as far as permitted product types, other than the cannabinoid vapes that got banned and are now being sold kind of in wonky ways, there's no restriction on the type of products, which is, again, like you mentioned, the innovation has been allowed to take place, and that's in every state, not just Texas. And then we've got limitations on the teacup side that is one of the driving reasons why people have an issue with teacup is because they can get the products that they benefit from outside of teacup and not in it. So hopefully that will be
agreed. We have fought many years to. There's a lot of stigma associated with pulmonary inhalation of THC, and it can be difficult to get our legislators and also people who grew up in the age of prohibition. You know, how many of you saw those "This Is Your Brain on Pot" commercials in the 90s? You know, like that's the generation that we grew up with. So it can be difficult to get legislators to understand, for example, the example I gave earlier, PTSD, veterans suffering episodic events. They need instantaneous delivery that sublingual or ingestible methods simply cannot satisfy. But to this date, one of the most accessible mechanisms and product availability for bioabsorption of THC is smokable flower. We don't have that within the program. We're very proud that we should have pulmonary at this point. I wrote a 10/1/2025 statutory deadline for dishes to have the rules done. They were not completed at that date. And as of today, what is it, January, whatever, we still don't have pulmonary.
Right.
Question about pulmonary. So in my read of the rules and the law, there is no restriction on flower. I know there's a restriction on smoking, but it does not appear that there is a restriction on herbal vaporization.
The problem is with the definition of smoking, the heating and burning for the resultant smoke. But I would agree with you. There's wiggle room there. DPS would not agree with you. They're very firm. Flower will not be permitted in the program.
But DPS is the rulemaking agency, not the
But you have to sue them. And when you are the largest market participant, you often don't want to be in the position of having to sue the people that you have to deal with daily that can yank your license at a whim.
And when you have only 3 licensees and then you expand to only, we're going to get 15 total?
15 total.
In the state of Texas.
Who's going to be the plaintiff? Right.
Well, there are some MSOs coming in with very heavy funding who will absolutely sue.
All right, age restrictions, customer base. This is the big change we've had this last fall. We were age gated on the Hemp side, finally. Both dishes and TABC got emergency rules out. The TABC rule, it both require verification of ID. And in the TABC final rules, you don't have to verify if the customer appears to be more than 40 years old. And we also had more conditions added on teacup, but still doctors are not allowed to practice medicine.
That is a personal quirk of mine, because in every state medicinal program, you have a statutory catch-all that says, for any condition for which the physician deems necessary. I didn't go to medical school. I'm not sitting there with the patient. I don't know that they've tried 13 other palliative or adjunctive therapies that are failed. It should be the doctor who has the discretion to say, like, everything else has failed, or I think as an adjunctive therapy, cannabis would work here. We don't have that in the state of Texas.
All right. Packaging and advertising. No real formal rules in teacup, but DPS practice. Everything's approved.
Packaging, we actually do. There are very stringent regulations on what has to go out. It's dispensed like a pharmaceutical, name of the product, patient, yada, yada, but advertising, surprisingly scant. Unwritten.
And then we've got a lot of proposals on the hemp side.
Which a lot of these are things that are going to help some of the problems that have been brought up. So the proposed rules have child-resistant packaging. They have warnings. There's certain warnings that are going to have to be on all the products. They are now going to make sure. So there's an issue with the CLE. Somebody brought it up earlier. There'll be QR codes and they will not go to. There'll be broken links. And so it looks like they're taking the QR code from the product. And so you have to have a website that will go to a link. And
which I think that's accessible for consumers, and I raised that in my.
But it's the highest issued citation, if I recall correctly, is because the inspectors go in there and they're scanning a COA and it's coming up for 2019 or doesn't come up at all.
Right. And in fact, when people ask me what product should I buy, I tell them check the QR code. And if it doesn't work, don't buy the product. One of the proposals, for those of you who were at the dishes hearing on the 9th, probably the most amusing moments, you cannot have imagery that attracts children, including images of celebrity. And Willie's Reserve showed up and held up a photograph of Willie Nelson and said, Willie Nelson is 92 years old. This is not attractive to children. So I hope Dishes sees it in their wisdom to save Willie in their final rules.
Yeah, they are like no cartoons, no images of children, not mimicking the trademarks, and no misleading packaging.
Which is trying to be a given. If you're out there selling some reefer pieces and stuff, get that stuff the hell out of your store. You shouldn't be doing that in the first place.
Or I will go find some lawyers to file a DTBA suit against you. Taxes, this is an easy one because it's largely the same. And, I don't think it's sunk into me that sales taxes are paid on teacup products, which is BS because it's medicine.
Well, I don't, it's not everybody pays taxes on them unless that's new. So
let's to each other up here. All right. Business model, legally enforced is, we've framed it. We do have the vertically integrated system on the teacup side, but maybe there's some loosey-goosiness in there in practice. Anything with that, Chelsie?
Not remotely. We would love to have multiple production facilities, but there's no leeway there.
And then on the hemp side, you can do what works for you. You can do what works best for your company, what works best for your expertise set. You don't have to do it all.
And this is a good point for me to address because this is something DPS has unilaterally created that is nowhere in the regulations that no one knows about. The department it's no secret. It's not a fan of hemp. There's a reason. The chief and everybody was up there behind Dan Patrick when he was throwing cereal at that reporter. Um, one of the things that people are wholly unaware of is when we open up a TDS dispensing location, for example, the most appropriate place for that to be is in a physician's office. A, because they're about the only people that will take us, and B, because it is a medication. So one of the requirements that was recently added is I have to go in and get that physician to personally sign under penalty of perjury that he has never carried a hemp product, or he or she, or that she or he never intends to carry one. The word hemp doesn't appear anywhere within our cup regulations.
I think, okay, so I'm going to suggest that that probably came up because there are doctors' offices who are simultaneously giving the prescriptions and then turning the customers over to the hemp shop that they also own.
Well, they may have
With their
like a
prescriptions
topical
are done.
CBD cream to pain patients, but why should that disqualify? What the hell does that have to do
Why
with for a dispensing site located?
Well, it seems like a collision of what's traditionally been in the medical field, keeping people from having a conflict of interest as physicians when they're selling products too. But on the other side is DPS trying to punish anyone who traffics in hemp. Traffic being perhaps the wrong verb there.
Yeah, none of our 9 conditional awardees who received the awards in the first rounds, they went back and amended the Cup 101 form to now include a secondary bubble that says, do you have any associations with the hemp industry? It's mandatory disclosure.
Yeah, that showed up in the application for the phase 2 applicants. All right. Consumer protections and patient protections. This, I hope, will be a big issue next session because there's a lot of really terrible things that are happening to individuals out there, whether it's a child custody case, probationers, and other contexts like that can come up in licensing.
You should tell the story you told me earlier, Pat.
Yeah, I've been in touch with a family in East Texas, and his physician was speaking here earlier today, I believe. His name's Joseph Ritchie. He is now in prison for 7 years. He was on probation. He'd had a history of alcoholism, had been raped as a child in juvie in another state, PTSD from that. He got into teacup. It quit drinking. It was really working well for him, and he tested positive for THC. And at the probation hearing, and he's not a wealthy guy. He's got a court-appointed lawyer. His physician offered to come testify. Court-appointed lawyer doesn't take it up. And the judge gave him 7 years in state prison for that. He has a child. The judge magnanimously stated on the record, I'll give you 7 instead of 10 because you have a child. Thanks. And the judge also made cracks on the record that teacup isn't real. And
we're the most highly regulated program in the entire United States. And that's not an exaggeration at all.
Yeah, and that case is on appeal, the probation revocation. I can't tell you how difficult it is to get a probation revocation really reversed. But man, do we need to change the law and make it with teeth so that judges who don't want to believe something is real that's written into statute can't do that to anyone.
And it has adverse implications, not only in our drug courts and criminal courts, but in our family law courts, in the workplace. There was a retired police chief who was working security. I called you on referral. They fired him because they found out he was in teacup, and they said, well, you can't use drugs, can't use drugs here. And there are relevant standards for that. Obviously, you shouldn't be out operating a bulldozer when you've just taken your medical cannabis. But immediately the next day, they hired him back. And I was very excited because I was like, this is an issue we haven't taken head on here in Texas, is the employee protections. We don't have, there are certain states who have said that the federal ADA applies to medical programs and you can't adversely penalize someone for their participation in the program. We don't have a statutory protection for a school nurse who is risking her life and liberty to give a pediatric patient sitting in that school their required medical dosage on a daily basis. So I routinely speak to schools who say, hey, mom's saying we got to give this kid his medicine at 2, but how am I supposed to, the nurse, they're on the line at this point. How are they supposed to go give this when nothing in the state of Texas protects them? And we need to fix that desperately.
Okay. It's 4:20, so I'm going to book. See what I did there? So we have a little bit of time for questions. That's the end of our chart. We want to say a little something about enforcement and raids. There have been some high-profile raids going on out here. Chelsie, you had a client raided a warehouse. What happened to that case after they... And tell us...
Yeah, the little black ones. So the DEA and Chief Dyer, who's the head of the Allen Police Department, who is, many of you saw him testify before the legislature in this last session. They showed up and raided these warehouses, took everything. went to my client's home, took his children's cell phones, every computer in the house, took all vehicles, seized the assets of every corollary account. It was a large family. They had real estate holdings, hotel holdings, nail salon holdings. DA froze all of the cash. And the whole world or the whole nation was watching these cases because it was the first time the DEA had gone and conducted one of these raids. We went out and hired an amazing criminal defense attorney. I tell my clients, if you get arrested, do not call me. You're going to jail. I don't do criminal law. Like straight to jail. So after fighting the DEA, and then the AUSA was very much so posturing, saying, we know what these people are doing. They're sending money back to the Middle East, which as predicate matter, my client is Indian. He was not sending money back to the Middle East. Yeah, accused him of terrorism, said these are falsified COAs. We know what you're doing. This is a client who pays me to do a monthly compliance obligation on a report on every single product they had listed on that distributor website. So I'm not only going and vetting the COAs, I'm having independent testing done to make sure that, for example, we don't have some of these products that are showing up with synthetics. I mean, they pay a phenomenal amount to stay compliant. Of all my clients, I'm thinking, why in the world this guy? So DEA is giving all these threats saying these guys are going to jail. 60 days in, we get a call saying, come get all your stuff, take it all back. We're not moving forward. So,
and that's been happening. And
you're clapping. We spent over $100,000 to get there. That's not right.
And then they went to jail, and they went away for their to go to jail at all.
No, because he wasn't on site.
So, like all the money froze and everything. There's collateral consequences that happen, whether it's in the TCAF side, the hemp side. If you're testing positive, you can lose your job. You can not get hired.
There's adverse immigration implications. Yeah. Now, CBP sent a letter to a retail shop in South Texas about 6 months ago that said, saw on your website, you're selling THCP. We're going to yank your immigration visa that you have here. That's a illegal substance. What are you doing?
The Border Patrol is jumping into too.
Yeah.
Oh, yeah. I had somebody tell me just a couple of days ago that they went to get on a cruise and somebody found one of the security was searching through her bags and found like a hemp vape pen. And I don't know. I told her, give me all the details because this didn't make any sense. But she ended up having to pay some money to somebody, got something in some sort of citation or something. And she mentioned Border Patrol and then got on the ship eventually. And now she has this, every time she travels, she gets searched every time. And she was denied. She was in the application process for global entry, and it got invalidated.
They're pulling global entry. I have a client who does mobile vending machines, and I have been in a long-standing fight with the Texas comptroller about their interpretation of a certain part of the statute that is wholly unsupported and will not hold up for court. But long story short, they issued 2 arrest warrants for my client without ever notifying him. They knew I represented him. I was communicating with the agency. He's getting ready to come back into the country, and he gets a phone call from the Department of Homeland Security saying your global entry has been revoked because you have 2 active arrest warrants out of Texas. And he's like, what? I mean, this man had never had a squeaky clean reputation. He's actually a pharmacist. And so due to that issue with the comptroller, his global entry is now permanently revoked.
And if you get picked up or arrested with a vape pen and it turns out that it is actually marijuana, that is the felony right away. And we don't have an affirmative defense that if you bought it from a store and you went in and you did what you were supposed to do and they sold it to you,
so go to jail.
Right. Then the customer could go to jail. A lot of those, you heard the panel before, a lot of them they're not taking those cases. But that's the risk. There's a lot of risk out there because there's so much of a lack of information and there's so much misinformation.
That's there was a big point we all three wanted to make, and that is regulators are not your enemy. And I know a lot of people in the industry can get kind of pissed off into like what's coming out, but the more you have dialogue with the regulators, the more you understand who they are and what their scope of power is, I think the happier everyone will be. And I wanted to give a shout out in our audience. We have the top brass from TABC here. Guys, give us a wave. Executive director and some of the general counsel and environment. Going forward, they may end up with a lot more responsibility as things shift around, given with the legislative session. But in a politically healthy state, the industries and regulators or politically healthy areas talk to each other a lot. And that's how you get to good results and clean product out there for consumers.
Well, right. One thing I want to mention, because we're at the end in the rulemaking process, just give everybody kind of an idea of what's happening with that rulemaking process. So the proposed rules from dishes on the consumable hemp program went out about a month ago. The comments were due in on Monday. they are now going to review all of the comments, and Dishes will then make another publication in the Texas Register responding to every one of those comments. So you get to get a little bit of insight into their thought process. And then they will tell you what they are moving forward with, what they've changed. Depending on what they've changed, they may have another comment period, or they may tell you what date those rules are going to be adopted. So I expect that there will be changes. I don't know if there'll be another comment period.
And quick look at what's coming ahead. We're waiting on Dishes to do that piece bit of work. We may see interim charges and hearings in the summer and fall. Election results, both of the primary and the general, are really going to matter. How does the cannabis regulatory issue play out in elections and the conversation, and also if it comes up in particular races where we feel like it changes the result, that's going to change the legislature's attitude next session.
And what happened in this session, like, it's a topic. It's a topic. The governor vetoed it. Yeah, this is a topic, and we have the opportunity to go make our voices heard even louder. And our voices worked this last session. The 18.5-hour hearing worked.
And while we're all thinking about these moving targets at the state level, we still have no idea what's going to happen at the federal level to make this, double plus difficult for anyone in the industry and for state regulators. All right, this QR code will link to the chart. We have a few minutes left. Are there any questions? Probably a lot, maybe few, maybe Heather's telling me you're out of time anyway. There's one back over there, Heather.
Got it in the back.
Yeah, you know that voice. Go for it.
I was curious about something y'all said earlier on the teacup program. I kind of wanted to make sure I heard it right, because it's unique, I guess, amongst marijuana industries, if that's true. The DPS collects samples and then sends from the marijuana program and sends that out of state.
Yes, multiple times in both the product approval process, R&D, and for finished product.
Isn't that like, I mean, I know
where you're going. It is an interesting practice. Let's just
okay. Fair enough. I just wanted to make sure I heard that right. I've worked in a fair number of states, and that is certainly unique.
You're saying it's irregular since Schedule 1 materials outside of interstate bounds? Calorie shot.
Thank you.
At Chelsie, I would imagine that's on top of the internal testing.
We have robust internal R&D testing and several checks throughout the process. I'm super proud to say we've never had an adverse event in any of our licensees in the TCUP program.
Any other questions? They'll go down.
Closer to alcohol
right now.
How much do you think it should be?
Good answer. Talk of that as a benchmark.
And how much are alcohol licenses?
It depends on whether you're a distributor or retailer.
Yeah, they vary.
A 4-tier distribution system.
$1,000 up to $3,000 range for a 2-year period.
2 years. Okay.
Yeah.
1 to 2,000 for a 2-year period.
Yeah.
That's the consensus.
Way in the back.
I'm wondering if you could elaborate on the products available under teacup, specifically pulmonary, vape, inhalable.
Sure. So we just submitted and got the first 2 pulmonary inhalation devices approved, but don't rely on what's on the Dishes website right now. I'm actually trying to get them to fix that. If you go to the Dishes pulmonary approval list, it's going to say the Jupiter MB4 and the Jupiter Palm Pro, which are both pulmonary inhalation devices that allow for inhalation of resultant material. But what the Dishes website is missing is there's a specific battery that was approved with those that allows for 2-second meter dosage to stay within the statutory dosage limitations. I'd love to be able to tell you that we have a pulmonary product to roll out. And again, expressly wrote in some statutory limitations because sometimes when you work with these agencies, you know that it can take a prolific amount of time for rulemaking. So there's a statutory deadline of 10/1 that was not met. Then there was rulemaking and comment process, and in the final, some new rules came up that caused a delay. For example, they required the dispensing organizations to personally attest the device is safe and effective. We don't make those devices. There's no way inconceivable, that I'm having the CEO of my client sit down and attest to a device being safe and efficacious when it's not his. So we had to go back and forth on that to get that issue fixed with dishes. First 2 pulmonaries were just approved less than 2 weeks ago. We're now awaiting DPS to approve the formulations that technically have been sitting with that department since May of 2023. We resubmitted in December, are still awaiting those, but I was also just informed by DPS and the CURT registry, there's a drop-down menu that allows physicians to select a particular type of product from tincture, oil, etc. There is an other button that would work perfectly right now. The physician could just click other, and type in pulmonary elation. But apparently it is going to take the agency 2 weeks to up to, I think 4 weeks was the balance of there to add one more little bubble into that drop-down menu. So when pulmonary is coming to Texas, I couldn't tell you at this point.
Last call for questions.
Yes, sir. But I don't.
Test anywhere. Yeah, you could test it anywhere. It's that comment was added to kind of explain, not explain, but like highlight the fact that some of these products are being tested in all kinds of places and coming with all kinds of COAs. And so there was a suggestion made to have those products be required to be tested in Texas. That never happened. So that was just a kind of a comment that like you're not required to test it in the state of Texas. It just has to be tested.
And one thing that's sort of odd about how our current state of regulation is the labs, you're correct, the labs that are testing plants in the field for pre-harvest testing have to register with the Department of Agriculture, but there's no oversight of them. They just send in the fee and the form, and that's it. They do have to be ISO certified. For the finished product, the way that Hemp bill was really originally written, there is this utterly bizarre statute that I always hated because it was like a logic test on the GRE or something, that if you did this, that, and the other, and A plus B equals C, then you don't have to test the final total product, which makes no sense. That statute's going to have to be changed to undo that, but we also don't have what a normal cannabis regulatory state might have, where a lab license is a different thing, and you have to be licensed and inspected and have state oversight to be testing cannabis products to make sure you're not cheating. And as a lot of people in this room know, lab fraud is a huge problem in the cannabis industry nationally. And Texas has not yet upped its game on really looking for that. Aside from if you do fake a COA in Texas, it's felony.
And there's like a ownership restriction. You can't have an interest in that.
Yeah, final question. Is there an event happening this evening, and how can people find out more information on their schedule at the bottom of Friday where they can scan a QR code?
Well, funny you should ask that. Heather, there is an event happening this evening in conjunction with Realm of Caring, and tell them how you can get information about that, because
Be happy to. At the bottom of the schedule for today, there is a QR code that you can scan for more information and to register. It's a party to end prohibition, and it's being hosted by Vicente and Realm of Caring. It's downtown, so not too far from here. Once you register, you'll get the address. I'm happy to support our friends hosting this party. Very well done, ladies.
that good. All right. Thanks, Sean, and we'll see you tomorrow. Right.
Yes,
Good
that's
set?
right.
Okay.
We start at 10 a.m. tomorrow. Thanks, everyone.
Hey, that